Good afternoon, ladies and gentlemen. The court is assembled in the case of State of Georgia versus, I don't have the right paperwork. I have the right.
You got Ms. Collins.
Yeah, Ms. Collins. I can't sound a case number. Madam Clerk, you got our case number pulled up? No?
It's 26R96.
26R96. Let me wait on that file. I've just finished with this one. Or the state can sound it for me. What you got?
Yes, Your Honor. As to 26R096, we're here for the sentencing on the state versus Ryan Tamel Cooper, who was convicted on all 8 counts of the indictment, and that being count 1 malice murder, count 2 felony murder, count 3 felony murder, 4 aggravated assault, count 5 aggravated battery, count 6 possession of firearm during commission of a felony, count 7 possession of firearm during commission of a felony, and 8 concealing death of another. Counts 2 through 6 will all merge. So what the court will be looking at sentencing him on is count 1 malice murder, count 7 possession of firearm during commission of a felony, and count 8 concealing death of another. And before I go into argument, after discussion with Mr. Edwards, we think we would like for Ms. Thornton would like to go ahead and make her victim impact statement when the court's ready.
All right. Ms. Thornton may come up at this time. Good afternoon, Ms. Thornton.
Good afternoon.
Good afternoon.
Your Honor and members of the court. I am the mother of Lacambria. I am here as a victim of what happened to my daughter. And as the grandmother of the child she left behind, my daughter's son, Jordan. I have lived through the unthinkable. When my daughter was murdered, Jordan was just a baby. The person who did this to my family is Jordan's father, and he's in this courtroom today. Now preparing for sentencing. He was found guilty on all 8 counts. Today I stand before you not only to speak about the crimes that occurred, but about the lifelong impact that has been forced on our family. Since the murder, my life has been shaped by absence and grief. Jordan and I had to build a new life out of this loss. Trying to care for him, raise him, and protect him from the pain that comes with growing up without his mother hurts. Nothing can undo what was done. Nothing can bring my daughter back. But Jordan deserves to know that he is loved, that he is not forgotten, and that the person responsible will be held fully accountable. I want the court to understand something clearly. This case is not only about what was taken from my daughter's life, it is also about what has been taken from us afterward. The chance to grieve properly, the chance to memorize her, the chance to have closure. Even now, the defendant refuses to tell where my daughter's body is located. provide that one piece of information that will allow me to grieve with dignity. Closure is not just a word for me. Closure is where you can finally go, where you can finally mourn your daughter without uncertainty, where you can finally have answers. Without the location of her body, my grief has no resting place. Every day is longer than it should be. Every day I'm left to live with unanswered questions that should have been resolved long ago, Your Honor, and members of the court. I am asking this court to take this very seriously. When a person refuses to provide the truth after such a crime, it deepens the harm. It prolongs suffering and keeps the victim family trapped in uncertainty. A sentence that reflects the full seriousness of what he did across every count of which he had been convicted and the devastation it had caused. I also want to be direct with the defendant, Mr. Cooper. My daughter was not just a case number. She was not a statistic. She was Lacambria Toomer to me. And she did matter. Jordan deserved his mama. I deserve the truth. You have an opportunity to give me that closure by telling me what my baby body is. If you have any heart left in you on her, before I leave here today, please give me that closure. Please tell me where my baby is, please. I'm begging you, tell me where my baby is. So I can go on with my life and Jordan can at least have a place to go. To memorize, I can't give my baby proper burial. The message that the court sends matters to me, to Jordan, and to every family that hopes the justice system will protect children and punish those who destroy lives. My family has endured enough 4 long years. Mr. Cooper, 4 long years. I was on feet. I was on hands. I was in places I had no business going. I was in woody areas, walking in water. I was going to places, I ain't even thought about going before. Day in, day out, I was out looking for my baby, because that's what a mama's supposed to do. I was there 4 years, 4 hard years. If you ain't gonna do it for me, do it for your son. Do it for Jordan. One day Jordan gotta grow up. He gonna wanna know. He gonna wanna know where his mama is. He gonna wanna know what happened to his mama. He's already asking questions. Give us that closure. Have a heart. Just have a heart. Give us that closure. Do it for your son. You ain't gotta do it for me. Do it for your son, please. My family has done enough. We had carried this law for too long. I asked the court for a sentence that matches the severity of the crimes and the long life consequences that follow. Thank you, Your Honor, members of the court.
Thank you. Any other statements?
Yes, Your Honor. I know Your Honor heard the over a week-long trial and heard the evidence, but I do want to point out a few things in that. And one is that we all heard the pattern of violence that this defendant, the ongoing pattern of violence that he showed against Lacambria Toomer. We heard 3 incidences leading up to the murder, one 4 months before the murder, 2 of which he had a firearm with him. We heard the incident in 2021, in July of 2021 at the salon, where he pointed a gun at her, where he hit her in the head, causing I think they said goose egg or a hematoma on her head, where she had to run into a business half naked, beating on the door. And when they asked the defendant about it at the police station, he's laughing. He laughs about her injuries. He's even holding his hand. It's on video. We all saw it. That shows what kind of person he is, Your Honor. Then we get to the trailer incident in March of 2022. She's called for help. Lacambria is trying to leave the trailer with Jordan, who is a newborn baby at this point, while the defendant is beating on her, causing her to drop the baby. A newborn baby hits the ground. And then what does the defendant do? He walks up to Lacambria and he stomps her and he kicks her. That's the kind of person he is. Then we have her just 4 months before the murder having to run to her family member's house, where she gets there because he's been beating on her again. And EMT and police saw the injuries. When she got to her, I believe it was her aunt or family member's house, they said she was wet. She had wet herself. She was so upset. And these are just the things we know about. We don't know about all the other incidents. But these are enough. It shows his ongoing increasing pattern of violence. There was multiple witnesses and evidence that showed that he's always got a firearm. He had a firearm at the salon. He had a firearm at the trailer tucked in his pants. We know he had a firearm when he killed her. And even after he kills her and disposes of her body, he's still got a firearm because he's got it in his lap when he's telling Tevin Davis about the brains on the roof of his car. The roof of his car, he's still driving around. That's the kind of person we're talking about. That is cold, calculating. I mean, there's just no other explanation, Your Honor. And when he's finally asked about her going missing, the only thing he says in the interview, well, I'm worried about my job. He's not worried about a son. He's not worried about anything. He's worried about himself, to the point that the next day he's already calling another girl. That's cold. This is calculated. It just shows the kind of person he is. You know, he goes on, even after killing her, hiding the body. He goes on hiding evidence. Continues to drive the car, like I said, still carrying weapons. And then, he didn't even care about his son. Well, did you call and ask about your son? No, I didn't. But he has taken Jordan's mother away. Jordan will never have his mother. Thank goodness he's got Miss Thornton and all of her family. But he has left him without a mother. And I think I cannot obviously say it as good as Miss Thornton's already said it. But basically, Mr. Cooper, the defendant, has sentenced Melissa Thornton to life without parole. He has sentenced her to life with no parole from the pain of this incident, no parole from the agony, and no parole from the hopelessness that she still lives with and will continue to live with. And that comes from, just like she said, not knowing where her child is, not being able to have a funeral for her child, not being able to have a place to go visit her child. All of that's been taken away. No closure, as she said. No peace and no closure. Everything about this trial, it's even beyond murder. He continued to commit crimes. He continued to show how cold he was. He sentenced her to that. And Your Honor, for that reason, we are asking that you sentence him on count 1, malice murder, to life without parole. And on count 7 and 8, we're asking that you do 5 years consecutive on count 7, which is required by law. And then count 8 would be 10 years consecutive to count 7. So what we are essentially asking for is life without parole plus 15 years. Thank you.
All right. Thank you, Ms. Mullis. Mr. Davis?
Yes, sir. Your Honor, the death of anyone is not something that we should take lightly. We certainly don't on the defense side. What we're here to talk about is the sentencing of Mr. Cooper after the jury has already rendered their decision. There is one thing I want to note to the court as the court sits as a 13th juror, and that's likely to come up, that should be noted at this time. That will be, I think, uncontroverted by the state. The expert, at least Mr. Englert, that was presented by the state has already been, his credibility has already been shot in any number of courts. He has already been exposed for giving opinions that are simply based on what he was paid. And in this case, I think that it will be shown that the testimony he gave was perjured. He talked about one of the cases in which he was getting impeached, where he contended that the person that he sent to help out in a murder had testified truthfully at trial. That case, the Chris Spann case, is uncontroverted that that defendant had been convicted based on the efforts of Rod Englert and his staff, and the individual that had testified falsely testified for the defense in the third trial and admitted that he had perjured himself for money on behalf of Mr. Englert. Why is that important? Because all of the experts based their opinion on the testing that was done by someone else. The experts did not do any independent testing. The medical examiner for the last witness, he didn't even have an office. He worked out of a UPS store. He based his testimony on what was done before. Bianca Falks is the GBI lab scientist who testified that the sample that was sent to her from the cushion of the car did not contain blood. That was one of those samples where that was not even a presumptive test. However, the medical examiner, although his test results were negative, which means he found nothing, he based his conclusion that Ms. Toomer had bled out in the car based on what he concluded Ms. Falks had said. And that was erroneous. So there is going to be an issue about whether or not these witnesses testified falsely, and the duty of the state to bring to the court's attention what it knew about their testimony. It's also uncontroverted that neither one of them, either Mr. Englert or the medical examiner, Mr. Upshaw, had actually seen the car. They testified based on pictures, and the medical examiner in the end testified he knows blood just based on looking at it in a picture. I want to bring that issue up because I think that the court should weigh the weight of the evidence that has come in. The court sits as the 13th juror. Although the state has made a number of arguments in their presentation, they have not made an argument as to why Ryan Cooper would deserve to spend the rest of his life in jail, which is typically reserved for demotanious individuals, a serial killer, etc. Someone who he would not, of course, as the court knows, be eligible for parole for 30 years. They presented no evidence that in 30 years, even if they believe he committed the crime, he could not be rehabilitated. And that's the hallmark test for the court to look at, is whether or not this is an individual incapable of being rehabilitated. We've heard no evidence of that. We've heard no evidence of a lengthy criminal history that is typically cited by the state when they're asking for life without possibility of parole. We've heard none of the things that are supportive of sentencing a man to life at his age and an opinion that he can't be rehabilitated. There's been nothing presented to the court. The victim's mom testified, and she's understandably upset. She was talking about Mr. Cooper identifying the body. Of course, no one had said to her that Mr. Cooper maintains his innocence, and that's actually an inappropriate argument to make. She's never spoken to Mr. Cooper. So there's no way that she would know what Mr. Cooper may or may not have said. Someone had to tell her that for her to come in here and repeat it before this court. It was an inappropriate argument. So again, Judge, there's been no argument made. There's not even been an attempt to argue that Mr. Cooper has had a series of convictions that would show that he is incorrigible, that he can never be rehabilitated. Even in one of the domestic violence incidents that the state cited, Mr. Cooper was determined to be the victim of one of those incidents. That's where the baby, quote unquote, had fell to the ground. That was the incident in which they were both arrested. And the witnesses testified to that. So, Judge, again, there's been no evidence that he is incorrigible, that he can't be rehabilitated, and that he should spend the rest of his life in jail without the possibility of parole. Thank you, Your Honor.
All right. Thank you, Mr. Davis. Anything else?
No, Your Honor.
All right. The court thanks Ms. Thornton for her courage in making her statement today, and her courage for sitting through this trial, which had to be a challenge. Presence every day. She walked out when she needed to, and she came back as soon as she could. So doesn't go without being noticed. Typically, close to what Mr. Davis said, I'll be honest, I've never sentenced anybody to life without parole. My unspoken conversations with myself said I always wanted to leave people thinking they had a chance. But the court finds this to be one of the most horrific trials that I've sat through. And my kudos to, I say what I believe. When people do bad, I say that. When they do good, I have to say that too. So I think the Dougherty County District Attorney's Office did an exceptional job in the presentation of this case. And the taxpayers of this county ought to be really proud of that. And APD, I'm not going to leave you out. If you couldn't, you had to help them out. So, okay. All right. So I do think that. But the evidence in this case was just out and out cringeworthy. And I don't cringe over a lot of things, but it was just cringeworthy. And I don't feel like I'm alone in that, based on the jury verdict that was returned in this case and the speed of that verdict. And it's a lot of other, knowledge. See, you start acknowledging people, you get in trouble. But Lacambria had a lot of support, and Ms. Thornton had a lot of support. There were a lot of friends, families, whomevers, who also attended this trial on a daily basis. And I thank you for your support of Ms. Thornton and Lacambria, okay? And Lil Jordan, okay? Did Lil Jordan, he has a school uniform, is that Lil Jordan? No? Okay, is Lil Jordan here? No. Okay, all right. But I say all that to say, the court, and I'm not going to go back through some of what I think I remember of the trial and the testimony that resonates so strongly with the court about the brain spatters on the ceiling of the vehicle. Although a part of me wants to empathize and understand Mr. Cooper, I can't get over what has been found to be his actions. So, without more, the court is going to send, and like I said, this is my first time doing this, Ms. Cooper. I've never sentenced anybody to life without the possibility of parole. But I am going to do it today. And so I've never done this, so the state is asking on that counts 5, 7, and 8 be consecutive.
Yes, Your Honor. Your count 7 has to be.
Yep, count 7 has to be.
Yes, Your
okay.
Honor.
So on the felony murder, no, firearm during the commission of a felony, the court will sentence you to 5 years. And on the count 8, concealing the death of another, court sentences you to 10 years consecutive to the 5. I'll look forward to the defense motion for new trial, where I am, or I'm sure you'll urge me to be the 13th juror, but we'll take up that at that time. Anything else do we need to do?
That's what I was fixing to ask, just
So what-
for clarification. So it's life without parole plus 15 years. Is that correct?
But I think, Your Honor,
I said 10.
the sentencing order should be the matter of hindering the discovery of the crime should be the next after life without parole, followed by the gun charge in that order.
Okay, so he'll be sentenced to life without the possibility of parole, which is count 1. Count 8, concealing the death of another. Count 8 is 10 years consecutive to count 1. And then count 7, possession of a firearm during the commission of a felony, is 5 years consecutive to count 8. Does that satisfy the state?
Yes, Your Honor.
Okay.
Judge, we would just object to that. I think that the possession of a firearm during the commission of a felony is to run consecutive to the murder charge, not to consecutive to the concealing the death of another. The statute doesn't require it to run consecutive to every charge. It only requires it to run consecutive to the murder charge.
Okay.
The state believes its order is correct.
Okay. I changed it at the request of the state, but we'll leave it like I just said it. And if we need to amend the sentencing order, we'll do that.
Okay. Your Honor, I've already been retained on the appeal. I think in this case, we're going to do a direct appeal, given the court's position. And one of the things I have to do is to make sure that, and I'll send just my typical motion, is that the time is extended for filing the transcript. I mean, I would assume in this case, the transcript may take 6 months or so to file. So I would just ask, and I'll submit the order to the court, that the court reporter be given 6 months to file the transcript.
All right. Madam Court Reporter, that's about right for you? Okay. So you're satisfied it can be done in that time? You are satisfied that it can be done in that time? Okay. 120 days is 120 business days. What if I give you 120 business days to get it done? Is that, I've never done that. I mean, she's saying she has 120 business days to get it done?
Yeah, and I'll submit the order to the court. When you're giving her
Where does that put us? We don't know. Is that 6 months? Essentially?
120 days is
Business
4
days.
months, sure.
Business days.
Business days. I just said 6 months to incorporate every day. But if we want to say 120 business days,
Why don't we give 120 business days? Does that sound good, Ms. Adams? We'll say 120 business days from
okay.
this date. Okay?
All right, that's fine, Judge. Okay, thank you very much.
Thank you. Yes.
So it's counts 2 through 6, are they merged with count 1?
Yes.
You know, is there any credit for time served?
Credit for time served. Thank you for asking.
Judge's time served is going to be May 31st, 2023 to current day, August 7th, 2026, 1,164 days.
Okay. Anything else?
No, Your Honor.
All right. We stand adjourned. Thank you all.